Okay, welcome guys back to another episode of the Property Law Alliance. Today I'm here with Bruno Simao as usual and Nicholas from SSLR. We've got two questions today, one eviction one and one is a tax one.
Before you go on, do you want to introduce yourself? Who are you and what are you doing here?
What am I doing here? So I was jumping straight into it. So welcome to the new phase. And so my name is Tuma. I'm part of the Bruno Simao law team. And so I've just decided to actually bring back something that we had in the past, which is Christopher Abrahams just hosting the experts. So the whole idea is to actually sort of open the communication, invite people in, and just allow for a different bouncing board, somebody asking the questions, just so that everybody can understand more simpler, as opposed to two experts having a very complex discussion amongst each other. So I'm hoping that can just bring a better value. If I can just maybe just help Nick and Bruno just sound better, basically. Yeah. So,
we need help, yes.
So that's the plan going forward. That's the plan.
Cool. Awesome.
Yeah. So two questions, as I was saying, one is an eviction one and one is a tax one. We will just start with the eviction one. It is a bit complex. It's one that's actually Nicholas is dealing with right now. So he will help me with the details as I just briefly describe it, and he will just have his input there. So basically, I believe there is actually a company, CC, that had two directors, and then both the directors actually passed away, all right? And then upon assessment, it turned out that there was actually a final deregistration of the company in 2016. And now there is then, somebody was now sort of in control of the company is now raising the eviction, right? So this brings into a lot of things that need to be considered as to how do we approach, then how does Nicholas approach this eviction? Because there's obviously laws in place who can act on behalf of the company, locus standi, and who's in control of the company, and that type of stuff. We'll look at membership versus types of stuff that we can sort of use to approach the eviction, Nicholas, right?
Perfect. Thank you. Yeah. So companies that have been deregistered. Okay. Now, one of the fundamental principles of legal proceedings, which a lot of clients don't understand before they actually approach a lawyer, is locus standi. Now, locus standi is a Latin term which just means standing before the court. Okay. It's just a principle that you have to have standing before a court before you can approach it. Okay, this just prevents people from approaching court with stuff that they have nothing to do with. Okay, it would be problematic if any person, you know, that came along on the street tried to evict your tenant when they're not a party to your particular lease agreement. Obviously, we don't want that in law. So locus standi is something very important. You have to demonstrate this when you do approach a court to satisfy the court that you are a person who's got the ability to bring this application or has an interest in a particular proceeding. Okay, it's something that has to happen in every single legal proceeding before a court. So it's very important. Now, when we talk about locus standi, generally these are simple principles. You know, if you are an individual and you want to approach the court for whatever reason, you are the right person and the person with the requisite locus standi to approach the court. We obviously have certain positions where your locus standi can be transferred to someone, where you give a power of attorney. And then when it comes to companies, obviously a company being a juristic entity can't act by itself. It needs representatives that act for and on its behalf, especially when you come to court. Okay, so you need someone with locus. And again, the courts take this very seriously. When you have a company, you can't just have anyone acting on behalf of the company. It's got to be someone who's got authority to act on that company's behalf, and it is mandated to act in that company or a CC's best particular interest. Okay, so this is something we have to demonstrate every time we go to court. Now, when it comes to companies, that's generally your directors of a particular company. When it's a CC, it's your members. And depending, there are a couple of other structures like trusts where it'll be a trustee. So each particular form of juristic entity has its own people that are going to act. Okay. Now, it's important. Those people that are specified within law, those are the only people that can act on a particular company's behalf. All right. If you are a person who is now trying to act on behalf of the company and you don't have that authority, you're not entitled to do this. And this is something that's very likely going to be challenged in a court. If you aren't a director or can at least show that at the time of institution of your proceedings, you're authorized to act on behalf of this company. Okay, so just a baseline, very general thing in law that needs to be taken into account. Now, with regards to the specific question, we have a CC. Okay, so in terms of a CC, the MOI for a CC, we've got directors who are, or members rather, who are the people who act on behalf of the CC. Okay, they are the people who, if you need to institute legal proceedings, it's going to be done by them. And there'll generally be a resolution that some legal proceeding is going to proceed. If an affidavit needs to be signed, one of those members is going to do it, unless there's some level of power of attorney. Anyone who's not one of those people or doesn't have a power of attorney from this particular members is going to be precluded from acting on behalf of the company. So it's important to know that. But in this particular scenario, okay, the company has been what we call finally deregistered. Now, for those of our viewers who don't perhaps own a company or haven't dealt with the rigmarole of doing a company, companies can be deregistered in circumstances where returns are not filed. They can be deregistered for a number of reasons, but the most common way we see is the failure to file annual returns with CIPC. Okay, so you have to do financials every year and you have to file them with CIPC. And if you don't do this for a 3-year period, okay, whatever your financial year end is attached to the company, your company is likely to fall into AR final deregistration. Okay, and that means the company is now deregistered. Okay, it's absolutely gone. Now, this brings a problem in certain circumstances where there is immovable property and the company which still owns that immovable property falls into AR deregistration, because now technically, as far as the law is concerned, that company no longer exists, okay? Which means it no longer has locus standi, okay? It can't bring any proceedings in front of the court because as far as the law is concerned, that company is not there anymore, all right? And this is problematic for obviously circumstances where there's immovable property which is still registered to that particular company. And what will happen in circumstances like this is that property which is registered within the company, okay, falls into the hands of the state. Okay, that's the that's the legal position. That property now falls into the state's hands. Obviously, in practice, this sounds terrifying. You know, if you are a business owner, it sounds like a scary thing. Please don't worry about this. I've never seen the state pitch up and start doing with the property what they want. The state obviously has absolutely no idea that this is the position and that they've acquired a new property. And luckily, CIPC is obviously very appreciative of the fact that, you know, if we have companies which are lapsing for whatever reason, there's got to be an ability for the owners of these companies to deal with this and handle the situation so that people don't just lose property. So it's a very easy process to get a property which has an immovable, or a company which has an immovable property in it re-registered. You know, there's literally an application you do have to end up filing. If you are AR deregistration, at least you have to file your returns, obviously, and there's a fee that is attached to this. But what is interesting, obviously, in the case that you've mentioned, is while you're sitting in that, while you're sitting in the status where the company has in fact not been re-registered yet, okay, you actually can't bring an eviction at that stage, okay, or at least the company can't. There may be clever ways in which your attorney can figure out to bring the legal proceedings, and that's obviously, with this particular case, we're in the process of figuring out a clever way to start the eviction proceedings and continue with them, notwithstanding the status of the company. But obviously, this is an unideal situation. You don't want to be letting companies lapse and then sitting in a situation like this where you have to find this creative solution. Obviously, you know, make sure you keep your companies up to date and you're filing all the requisite documents with CIPC that you need. But insofar as the simple answer is can a company in deregistration bring an eviction application to evict its tenants? No, actually it can't. It doesn't have the locus standi to stand in front of the court and ask for the relief for an eviction. So it's a very tricky situation, which, you know, ordinarily, and you know, this is going to require a re-registration of the company, and then because the directors in this particular circumstance have all passed away, you're going to have to deal with the shares or the membership of the CC. That's going to have to be transferred into the whoever person's name it is by the executors of the estate. So you have to perhaps reopen the estate. It's a very, very complex and a lengthy process in order to get all this done. So really, make sure you keep up to date with your requirements by CIPC. You don't want to fall into a similar situation.
Absolutely.
Well,
absolutely.
Thank you, Nick. It was a very complex question from the beginning, but you've ironed it out quite well. I've got one little brief follow-up question with regards to that, because locus standi seems to come a lot. So my question is that if then this application is brought against me, or I'm the one being evicted, and I realize that, wait a minute, the people bringing this application don't have locus standi, what then becomes my sort of approach? When do I approach the court? At which stage the proceedings to bring up that they don't have locus standi? At the beginning, somewhere in the middle, towards the end? Like what's my reaction to that? Like, just quickly, maybe just bring me into that.
So it's an interesting thing. It's a high level legal argument with regards to locus standi, and especially fights over locus standi. This is a very common thing, especially, you know, in eviction proceedings. I mean, we get it all the time, where you'll have a tenant who's disputing the ability to bring the eviction application. We have a lot of tenants who, you know, have a dispute over ownership of the property. I mean, that's a very common opposed eviction proceeding, where again you have to deal with locus standi and the ability. What is important, okay, from the case law that we know, is that locus standi is something that is important at the institution of any proceedings. Okay, so the ability for a company or a person to institute proceedings, they must have, generally, if it's a company, you'd require a resolution by that company to institute proceedings or pursue whatever you want in a court. And that resolution needs to happen before the institution of any proceedings. Okay, there is strong case law to say that if, say, a proceeding has been instituted with and there were no proper resolutions for the institution of those proceedings, this cannot be ratified at a later stage. So you can't start with your eviction application. They sort of challenge you, and all of a sudden you produce a resolution after you have been challenged for your locus standi. That already is problematic, and courts will not allow that, because already the start of your proceedings was not properly authorized, and so the whole process is sort of. So you need to be very careful, and we are very careful, obviously, about institution of proceedings. Are we in the right place? Have we got the right things in place? So if someone challenges locus standi, we can say, no, we're properly resolved. We are properly before this court.
Okay. But yeah, thank you very much for clearing that part up. Very complex, but we will be trusting you with that.